is case number 23-240-077. Stephen Johnson versus Bozzi Auto Sales LLC. This is a small claims bench trial. This is an appeal. The appeal is de novo. That means it's brand new. There is no appeal from my decision. Because this is a small claims matter, there is no record in this case. So I shut down the JAF system. Could you raise your right hand, sir? You swear affirm testimony you're about to give be the truth, the whole truth, nothing but the truth, so help you God?
Yes, I do.
Could you raise your right hand, ma'am? You swear affirm the testimony you're about to give will be the truth, the whole truth, nothing but the truth, so help you God?
Yes, I do.
Mr. Johnson, please proceed.
So yeah, we're here because I purchased a used vehicle from the defendant, which they misrepresented the condition of, and this cost me $6,000 in damages. I was made aware of this listing on Auto Trader. The advertisement for this car clearly stated that it was in good condition and pre-inspected, which I've included on the top of page 4 of my evidence document I've submitted, if you have that.
I have it, and I have reviewed.
Okay. I talked to the defendant multiple times over the phone asking about this car. They agreed to inspect it again for me and told me it passed. When I was on site, I also specifically asked about leaks and rust damage, and they told me it had nothing in need of repair. And so this led to me purchasing the vehicle for $6,100. However, that very same week, I took the car to the mechanic and who identified numerous severe. I'm sorry?
The mechanic you're referring to is Convenience Auto?
Yes, the first mechanic. That same week, and they identified numerous severe issues with the car, including leaks in power steering fluid, engine oil, transmission coolant, and brake fluid. I've included the entire report on pages 6 through 11. I also want to point out a note from the owner saying that these types of damages cannot happen in just a couple of days and must have been present at the time of sale. I've blown up some of the pictures from this report on pages 13 and 14. We can clearly see a lot of leaks happening here. On the bottom of page 4, the power steering fluid was leaking so bad that it was puddling during the time of their short inspection. On the top of page 14, we see corroded brake lines. And on the bottom of page 14, on the bottom left, is the area underneath where I parked the car, versus on the bottom right, the area just behind my car, showing clean pavement as this street was resurfaced recently before I bought the car. So at this time, I took the car back to the defendant. I told them this is not what you told me it was. I tried to sell it back to them. They would not. They did perform some attempted repairs on the vehicle. One of the brake lines and part of a power steering line. But they insisted nothing else was wrong. So at this time, I got the car back and took it to another mechanic. This is the Hoover Street Auto Inspection that I've included on pages 16 through 20. This identified essentially all of the same issues as the first report, including, I'll point out on page 18, they list all of the leaks they found, which again were leaks in engine oil, transmission coolant, power steering fluid, and brake fluid. So even aspects the defendant had attempted to repair or in some cases partially repaired. The cost estimate to fix these leaks, as well as the suspension that was rotted and in need of replacement, is over $5,000. Of course, the car is worth nothing close to that. I bought this car to use for work. I need to be able to drive at distances on the highway. In its condition, it can't reliably do that. So I intend to get rid of this car as soon as this case is over. I've been exploring options to sell the car. The highest offer I've gotten is $900. I was also able to find record of what I believe is the purchase of the car by the defendant at auction for $800. And so I think that is the value of this car, $900. When we add up what I spent to buy the car, what I've had to pay for inspections, and what I have to pay for insurance, because the car is financed, I can't drop insurance until I pay off the loan. The damages are $6,900. The car's worth $900. That's why I'm asking for $6,000, which I believe I'm legally entitled to, as the sale of this car violated the Michigan Consumer Protection Act. I've included a legal memo referencing the specific subsection. I found that I believe this falls under subsection 9031E, which states that, quote, representing that goods or services are of a particular standard, quality, or grade, if they are of another, end quote, is an example of unlawful commerce. I think that's clearly what happened here, and resulted in, like I said, $6,000 in damages that I'm asking for. And I think that is all I have to say, so I'm happy to answer any follow-up questions.
What is your education level?
I got my PhD. I just got my PhD last year.
Did you read the contract that you signed when you bought the car?
I did. I'm aware the car did not come with warranty. However, I don't think that I'm arguing, I think, for misrepresentation of the vehicle prior, resulting in the contract. I'm not arguing under warranty.
Do you have any legal support for your proposition that you may maintain a private action under the Michigan Consumer Protection Act, as distinguished from those actions being reserved for the Attorney General of the state of Michigan?
I'm sorry, could you repeat that, Your Honor?
Yes, sir. I'm asking you, do you have any legal authority for your proposition that you can maintain a private action under the Michigan Consumer Protection Act?
I'm not sure what exactly you're asking.
Okay, thank you. Let me hear from Ms. Bozzi.
Okay, so yeah, he did purchase the vehicle. When he came in before purchasing the vehicle, he was here for at least 4 to 5 hours checking out the car. His complaint, or a question, I guess, was the blinker works, but it didn't make a noise inside the car. And if we'd be able to fix that, which we said no. And the radio was the main concern for him. We offered for him to take the vehicle to go have it inspected by his mechanic or another mechanic. We also offered for him to lift up the car here to take a look at it. He declined. Then he purchased the car. When we were doing the paperwork, he specifically asked about the as-is form. I explained it thoroughly. He read it, he signed it.
What did you tell him about the as-is form?
That there's no warranty, and that basically what the as-is form says, like right above where he signed, it says everything that could be wrong with a used car. And I just told him that there's no warranty and we're not selling. It basically states that we're not selling him a warranty or promising him a warranty. So he continued to go ahead with the purchase. So then I did include in our appeal, our email conversation, where he did bring the car back. We did agree to fix a couple of the main concerns. A lot of the other things on that report were just like, tires and stuff that is kind of common with used cars. We still agreed to try to make him happy and fix a couple of those repairs. And according to him, it still wasn't fixed. I don't know exactly how much longer. It's in the paperwork here that you have, but we agreed to have a different mechanic look at it because maybe they just didn't do their job the first time when they tried to repair those two things for him, but he declined. And then I ended up getting the paperwork for the lawsuit.
All right, Mr. Johnson, were you given at the time of the sale the opportunity to inspect the vehicle?
I was able to inspect the vehicle, yes.
How much time did you spend doing that, sir?
Well, I looked at multiple vehicles when I was
Also, I'm
there.
asking you, how much time did you spend inspecting the vehicle?
On this particular vehicle,
Yes, the one you bought. Yes, sir.
I would say about maybe an hour, but I never looked underneath it.
Were you offered the opportunity to have the vehicle put on a hoist to look at it?
I don't recall being offered so.
So does that mean it was not, or you don't recall one way or the other?
I don't, I was not.
All right. Do you have any background in automotive technology or in automobiles?
No, I don't.
Had you owned an automobile before this vehicle?
Yes, in fact, I actually owned this exact same make and model just 4 years earlier. And so I thought I knew what I was getting into with this.
Is there anything else you want to tell me, Mr. Johnson, about your claim?
Yeah, I would like to state that I'm sorry. Sorry, can I have 1 second? I would like to clarify, I think some points made by the defendant that I disagree with. They did not allow me to have the car inspected by my mechanic. They did say I could get it inspected, but the mechanics that I asked to get it inspected with were too far away. And they also, I don't know what was mentioned about getting the car inspected after they worked on it. I don't think that ever happened. After they attempted to fix the car, I told them that I was going to get another opinion, and that was how that conversation went. They did not offer to do anything related to that in the area.
Is there anything else you want to say?
No.
Ms. Bozzi, is there anything else you want to tell the court?
No, Your Honor.
Mr. Johnson, you have the last word because you have the plaintiff. You are the plaintiff. You have the burden of proof. Is there anything else you want to tell the court?
I think all of the photos and testimony from multiple mechanics that I took this car to speak volumes in terms of evidence for misrepresentation. So I don't have anything else to add.
Thank you. I'm prepared to rule on this matter. This is a claim ultimately for breach of contract. Claim is that the vehicle was sold by the defendants, and it was not as the parties agreed it should be. The problem with the argument here on behalf of plaintiff, who has the burden of proof, is that on the face of the sale document, the document that was provided for me as part of the information provided by Mr. Johnson, car sold as is, no warranty. You're an educated man. You elected to buy a car without an inspection. You elected to buy a car without a warranty as is. The parties agreed onto a sale price on the basis of an as-is situation. The Michigan Consumer Protection Act does not provide for a private cause of action. It instead provides for opportunity for the Michigan Attorney General or some agent of the state to bring action saying there has been a violation of the Consumer Protection Act. It is therefore the ruling of the court that the defendant will win. Plaintiff gets no cause for action. Plaintiff has failed to prove his case. Plaintiff bought a vehicle that clearly needed help. but bought it as is. As is exactly that. What you buy is what you get. I'll send out an order today and good luck to you both.
Thank you.